Capitol Grill. This hearing of the Committee on Judiciary, Subcommittee on Commercial and Administrative Law will now come to order. Without objection, the Chair will be authorized to declare a recess of the hearing. I'll now recognize myself for a brief statement. One of this subcommittee's duties, obligations, is to oversee the activities of various components of the Department of Justice, over which the subcommittee has jurisdiction. These are also the duties of every committee, to have oversight over the administration. And just as important for administration that has the majority as it is when the administration is of the other party. But the Civil Division is why we're here today. The last time the subcommittee held an oversight hearing on the Civil Division was in 2003, a long time ago, when we invited the Civil Division and 4 other DOJ components to testify at the same hearing. Given the long time period that's elapsed since the last hearing, and given that a new administration has taken over since then, we concluded the time was ripe to use due diligence and have the oversight hearing that should have been held during the last 6 years. I thank Assistant Attorney General Tony West of California, Points West, the head of the Civil Division, for appearing before us today and to report on the division's recent activities. The DOJ Civil Division is responsible for litigating a broad range of matters on behalf of the government, defending the constitutionality of federal legislation, recovering money for the U.S. that was lost through fraud, enforcing federal consumer protection laws, defending immigration enforcement actions, and representing the United States in habeas cases. Approximately 88% of the Civil Division's work is defensive in nature. While there are many topics we could cover, I want 2 areas of interest, or to me particularly, we'll look at. First, learn more about the Civil Division's role with respect to the ongoing investigation of the explosion and sinking of the Deepwater Horizon oil rig in the Gulf of Mexico, as well as the spill that we are experienced, and will experience. The government's latest estimate is 60,000 barrels of oil, about 2.5 million gallons each day. So the estimate seems to go up every few weeks, and we don't know how much oil is out there. I know the Civil Division has been working with other Department of Justice components and have been since the initial explosion, and to investigate the facts and coordinate the government's legal response with all the federal agencies involved. Appreciate that the Attorney General has made clear that taxpayers will not pay a dime for any of the cleanup costs associated with this bill, and that's important that BP pays. And of course, we've had some progress with the President. I'd like to know what the Civil Division's role will be in ensuring that all responsible parties are held accountable. I also want to applaud Judiciary Chairman John Conyers' leadership on this issue and for introducing 5503, the Securing Protections of the Injured from Limitations on Liability Act, or SPIL Act, which we had yesterday in a markup. That bill is needed to patch up a lot of the holes and were exposed by the Deepwater Horizon explosion. And I would hope that we could pass this unanimously and get it through on a bipartisan measure. I would also hope that Memphis wins the NCAA football next year, but that's not going to happen either. Additionally, I believe the administration should consider placing BP into receivership. Not a light suggestion, but one that I think we should consider. First, Robert Reich mentioned it. He thought it important because it would put the federal government in a control position, taking over this bill and making the decision so there's not a conflict of interest on whether you get the oil or whether you stop the spill. And I'd like to know what your thoughts are on how that could happen. My thoughts on receivership are more because I don't trust them, and I think we need every dollar they've got to pay all the claims they'll eventually be responsible for. And has the Justice Department have looked at receivership and the burden that would be needed to be met to go into that area? Second area of interest for me in the Civil Division's role with respect to ensuring transparency and government openness. Throughout my career, I've advocated sunshine. To that end, I've been a strong supporter of revealing to the public as much as can be revealed about government decision-making. One of the things I found most disconcerting about the previous administration was its penchant for aggressively imposing government secrecy under the guise of national security. This tendency manifests itself in several ways, including in the broad invocation of the state secrets privilege and the vigorous defense of agency decisions to deny requests for freedom under the Freedom of Information Act. I recognize that under this present administration, the Department has instituted new policies in both these areas. I'd like to know how these policies are being implemented in practice. Given the broad range of issues the Civil Division handles, I know there will be other areas of inquiry from other members. The issue about fraud, which you look into, which I appreciate, and I don't know if that there's any monies that you deal with in some of these New York situations with Madoff and some of those folks, if we get involved, is there money from the United States government tries to collect that we may be owed in those hearings, those matters. Anyway, I appreciate the willingness of the Assistant Attorney General West to appear for the subcommittee. I look forward to his testimony, and I now recognize my colleague, Mr. Franks, the distinguished ranking member of the subcommittee, for his opening remarks.
That's a good opening, isn't it? Well, thank you, Mr. Chairman, and thank you, Mr. Attorney General West, for appearing before us today. I want to just express my gratitude to the Chairman for holding this hearing. I think the oversight of the Department of Justice and its components is one of the Judiciary Committee's most important obligations. The Civil Division plays a very important role in many of the Department's missions, from the global war on terror to combating fraud against federal health care programs. I mean, a whole range of things. And I commend the Division staff for their hard work across the wide spectrum of the Division's responsibilities. However, as you might imagine, I'm concerned that the Division has become distracted from its important mission by engaging in politicized litigation over the Arizona immigration law. Now, I'm from Arizona, so that probably doesn't shock you terribly. But Mr. West, not only has the Department announced that it plans to challenge the Arizona law, but I understand that you traveled to Arizona to meet with state officials about the law. And I guess I can't help but question why, with the wide range of important items the Civil Division has on its plate, that time is being spent preparing challenges to the law. The people of my state are really just trying to do what the federal government has failed to do, which is to enforce America's immigration laws and secure the border. The Department's proposed lawsuit against Arizona, I think, is irresponsible and insults the views of the majority of the American people who support the law on its face. And I know the law has engendered a great deal of criticism, but analysis demonstrates that the criticism really is unfounded if you look at the arguments that are made. Critics claim that the law promotes racial profiling, and yet if you read it, the law expressly prohibits racial profiling 4 separate times in the text. Critics claim that the law requires citizens to carry identification that they otherwise wouldn't be required to carry, but federal law has actually required non-citizens, including visitors and lawful permanent residents, to keep their registration documents on their person. This has been the law in America for 50 years. Additionally, critics claim that the law requires police officers to stop people on the streets to question them about their immigration status. But the provision of the law about questioning one about immigration status can only take effect if police officers have made a, quote, lawful stop, detention, or arrest in the enforcement of any other law or ordinance. Of course, or in other words, the individuals may not be stopped simply on the basis of suspicion and ask for papers. Now, I will just simply tell you that Arizona is trying to take a reasonable constitutional approach to dealing with a problem that has really been ignored by the federal government, of which I take my share of the responsibility. So, Mr. West, I hope that, the department that you work with can reconsider its decision to file the suit and look at some of the things that we've mentioned today. I'm sure the Civil Division's time and resources could be better spent cracking down on fraud against the federal government, defending lawsuits, and going after those who have taken part in mortgage fraud schemes that have caused so many Americans to lose their homes. My state needs the law to protect our residents, secure our borders, and preserve jobs for our unemployed citizens and legal immigrant workers. The department should not compound its lack of immigration enforcement by attempting to strike down the Arizona law. And again, I say that being a member of Congress from Arizona, and I know that there are varying perspectives on this, but nevertheless, everything I've said about the law is accurate. And I appreciate you being here today, and I appreciate the chairman for bringing this hearing to the forefront. Thank you.
Thank you, Mr. Franks. Appreciate your statement. And I'd now like to start with our first panel of witnesses. There's nobody but Mr. King, would you like to make an opening remark?
Thank you, Mr. Chairman. First, I'd want to address that I'm going to turn my attention to the this department, some of the things that are going on within justice, and I have had a number of public statements over the last couple of weeks that focus on the lack of objectivity on the part of the Department of Justice. And I think that when we talk about law, Lady Justice needs to remain blind, and I'd like to think we have to re-blindfold Lady Justice. And so I want to focus on that. There have been a number of decisions that have been made within the Department of Justice that I think were anything but that. And if we're going to have a country that grows together, heals together, and one that can be unified, one that understands that we have something that is an overarching concern, which I will call it cultural continuity, the idea that we're Americans joined together for a common cause with a common history and a common belief system. And that's what unifies us and strengthens us, and it allows us then to incorporate the differences between us and use those differences as a strength. If we allow for the division of us, or even the suspicion of a built-in bias of any kind, then that divides us and weakens us as a people. And so my underwriting theme here is a belief in the Constitution. That should be our default system, and a belief in a rule of law that applies to all of us, regardless of who we might be. And I think that when we start putting labels on people and then providing a level of justice, whether it's in the criminal or the civil division, then it's something that undermines our country and diminishes our ability to ward off our enemies, and certainly diminishes our ability to take this country to the next level of its destiny in a positive way. And so that's as positively as I can express the things that are in my mind right now, and I look forward to the testimony from the witnesses today. Mr. Chairman, I yield back the balance of my time.
Thank you, Mr. King. Mr. Chu passes. Thank you, and we will now start with our testimony. And I'm pleased we have a system of lights, or a light in this circumstance. Green means you're started. You've got 4 minutes till it turns yellow, and yellow is the last minute, a total of 5, and red means over, hopefully. And if you are finished, you'll be one of the few. But we have the lighting system. After your testimony, each person will have an opportunity to question you for 5 minutes, and maybe have a second round and have other questions. So our first witness is Assistant Attorney General Tony West. Mr. West was nominated by President Obama to be the Assistant Attorney General for the Justice Department's Civil Division January 22, 2009, confirmed by the Senate April 20. From 93 to 94, he served as Special Assistant in the Department under the direction of U.S. Deputy Attorney Generals Philip Heyman and Jamie Gorelick, as well as Attorney General Janet Reno. From 94 to 99, he served as Assistant U.S. Attorney for the Northern District of California, later served as Special Assistant Attorney General, appointee of California Attorney General Bill Lockyer. Prior to his return to justice, he was litigation partner in San Francisco at Morrison and Forster. His trial practice there included individuals and companies in civil and criminal matters. Thank you, Mr. West, and you can begin your testimony. You need to turn on your microphone, and we need to turn on your button.
How's that? Much better?
Good.
Thank you, Mr. Chairman, Ranking Member Franks, and members of the subcommittee. It's a great privilege for me to be here, to appear before you at this hearing to discuss the work of the Justice Department's Civil Division and to respond to any questions you may have. As you know, the Justice Department's Civil Division represents the United States in a variety of matters. Virtually every executive branch agency, as well as the President, cabinet officials, and members of Congress, are clients of ours at one time or another. With nearly 1,000 attorneys and over 400 support staff, the Civil Division is the Justice Department's largest litigating component, and the cases we handle touch upon virtually every aspect of this administration's policy priorities and the federal government's operations. And as part of our mission, the Civil Division defends the constitutionality of congressional statutes when they are challenged, as well as the lawfulness of government regulations. We seek to recover monies lost to government through fraud, waste, and abuse. We help to administer sensitive national compensation programs, such as the Radiation Exposure Compensation Act. We enforce important consumer protection statutes, and we represent the government in a wide range of cases, from contract disputes to tort cases, from loan defaults to immigration. Since assuming this position in April 2009, I've focused on three main priorities for the Civil Division: protecting the American people, protecting taxpayer dollars, and protecting the nation's consumers. Protecting the American people remains the Department's highest priority. Part and parcel to that, the Civil Division is currently defending around 140 habeas corpus petitions brought by detainees held at the detention facility at Guantanamo Bay, Cuba. In these cases, we vigorously defend our national security consistent with the rule of law. Moreover, our attorneys have performed excellent work in the area of terrorist financing, defending the government's actions in court when they are challenged to help shut down the flow of money to international terrorist organizations. We're particularly proud of that work. In terms of protecting taxpayer dollars, we've enjoyed significant success. Since January 2009, the government has recovered approximately $4 billion in civil fraud cases. And when that's coupled with the criminal recoveries from the Civil Division's Office of Consumer Litigation criminal cases, the Civil Division has, standing side by side with U.S. attorneys around the country, obtained over $5.7 billion in civil and criminal fraud settlements, judgments, penalties, restitution, and forfeitures. Healthcare fraud, of course, comprises the largest category of our fraud recoveries. Since January 2009, the Civil Division has recovered over $3 billion in all healthcare fraud matters, with the largest of those matters being pharmaceutical and medical device industry cases. But our efforts to tackle fraud don't end with healthcare. They extend to other areas as well. We have actively pursued economic fraud. We seek to recover ill-gotten gains for the benefit of fraud victims. Our increased enforcement efforts in this area, and particularly in the area of housing and mortgage fraud, have increased recoveries in this area from $15 million in 2008 to $52 million in 2009 and the first half of 2010. And in fact, last week we announced Operation Stolen Dreams, a mortgage fraud sweep which involved over 190 civil enforcement actions, including recoveries of more than $147 million in mortgage fraud. We've also been very vigilant in our efforts to root out fraud in connection with the procurement of goods and services used by our military and civilian agencies, including fraud affecting our men and women fighting in Iraq and Afghanistan. Since January 2009, procurement fraud cases have accounted for approximately $645 million in recoveries, more than the Department's procurement fraud efforts in 2007 and 2008 combined. Finally, the Civil Division continues to be at the forefront of our efforts to protect consumers through vigorous civil and criminal enforcement of our federal consumer protection laws. Mr. Chairman, my written testimony describes in more detail other areas where the Civil Division is actively engaged and where we feel we may actually need additional resources. The Department's work in supporting the federal government's response to the Deepwater Horizon oil spill is one example. I'd be happy to address those other areas should you have questions. And again, I thank you for the opportunity of appearing before you today.
Thank you, General West. I appreciate it. And you were perfect, even though I think our lighting system failed. Tell me about the Deepwater Horizon. What are we doing? What are we going to do?
Well, Mr. Chairman, soon after the explosion on the Deepwater Horizon, the Attorney General sent Ignacio Moreno, who is the Assistant Attorney General for Environment and Natural Resources, and myself down to the Gulf, where we engaged primarily in advising the federal agencies responsible for the for being first responders on the scene in any legal advice that they may need, but also to enforce the law, because it was important early on to make it clear that we would hold the responsible party, BP, accountable for every dime of removal costs, cleanup costs associated with the spill. Since that time, both Ms. Moreno and myself have returned to the Gulf. We've been there with the Attorney General. The Attorney General has acknowledged the existence of civil and criminal investigations into the causes of this explosion, and our intent to hold individuals accountable for not only the financial damage but the natural resources damages as well. We at the Civil Division have engaged in ongoing discussions with BP and with Transocean, making it clear to them what their responsibilities are as responsible parties, and that extends to efforts that were led by Associate Attorney General Tom Pirelli from the Department of Justice to help negotiate the creation of this $20 billion escrow fund, an independent claims process.
Will you be participating in any way in the escrow fund and meeting out or ferreting out the claims?
Well, it's important that that claims process be truly independent. Certainly the Department of Justice anticipates it'll be consulted as protocols and other details are being worked out with the creation of the independent claims process, but it's very important that it have integrity, that the American people see it as an independent process, and that's what we're committed to.
Let me ask you about FOIA claims. The Civil Division has resolved FOIA cases so as to promote President Obama's agenda of transparency and openness, but the Civil Division has litigated multiple FOIA cases that originated under the Bush administration policies. How do you reconcile that? Is there really a change in policy?
Well, last year, in fact, the Attorney General did issue a new FOIA guidelines policy. It is one which puts forward the administration's presumption that we will be an open and transparent government. In fact, the presumption is that in response to FOIA cases, we will be transparent. We will seek to disclose whenever we can. Sometimes with regard to the Department of Justice, of course, that's a little tricky because we often have confidential criminal investigations going on. But notwithstanding that, the intent is to, wherever we can, err on the side of disclosure. And that policy has not only been communicated throughout the Department of Justice, throughout the Civil Division, but we are communicating that to our client agencies as well.
But don't some of these Bush administration FOIA cases that y'all are pursuing because of a continuum theory, I guess, that they might conflict with Obama's positions, the president's positions, and don't we have discretion and we don't really have to pursue those? Why are we pursuing them, and why are we maintaining certain policies of the previous administration that are counter to hope and the future?
Well, without commenting on any particular piece of litigation, which I wouldn't be able to do, I can say as a general matter, there are cases, of course, which any administration inherits, and they obviously pursue them in accordance with the law and with the facts of those cases. And so I can assure you that with regard to how we view FOIA cases and how we evaluate our disclosure obligations in those cases, they are consistent with the President's preference for an open, transparent government. They are consistent with the Attorney General's new policy.
Let me ask you this. In March, the National Security Archive at GW audited the administration's performance with respect to FOIA requests and found that only 4 of 90 federal agencies studied showed both increases in information released and decreases in denials under FOIA since the implementation of the Attorney General's 2009 memorandum. What steps will the Civil Division take to increase the number of agencies that show both increases in releases and decreases in denials? The statistics seem to say that it's the same game. And sometimes it does happen that the administration comes in, and an administration that used to be against national security letters because they were part of the legislative oversight, then once they become part of the administration, they fall prey to the same type of beliefs that sometimes the executive would have, that, oh, this is mine, so I'm going to do it. Well, it seems like there should be, sometimes there's a conflict. And why have the departments, the statistics say we're not doing any better under FOIA than happened with the Bush administration?
Well, with respect, Mr. Chairman, I think the jury is still out on exactly how, at the end of the day, how our FOIA performance will be evaluated. As I know you appreciate, the policy, the fact that the policy was issued in the spring of last year, it still takes time, of course, to make sure that that change in policy, that change in attitude is something that is communicated throughout the federal government and that it is communicated throughout all levels of the government. that does take some time, but I can assure you that when it comes to evaluating these cases and when it comes to making the decisions about disclosure, not only are we obviously taking into consideration the existing law and the facts of the case, but what is governing and guiding our work in that is the new policy as articulated by the Attorney General.
Thank you, Mr. West. I have a red light. Mr. Franks has a green light.
Well, thank you, Mr. Chairman. Again, Mr. West, we appreciate you being here. In fiscal year 2009, the federal government's health care fraud and abuse control program returned about $2.5 billion to the Medicare Trust Fund. Considering that taxpayers are estimated to be losing anywhere between $24 and $80 billion per year to the Medicare and Medicaid programs, and I think that it's my personal opinion that under the government takeover that is coming, that's going to increase precipitously, and it seems to me that the Justice Department needs to be doing more to combat healthcare fraud. What additional tools and resources does the Civil Division need to combat healthcare and fraud like that perpetrated against healthcare programs more effectively? What do you need?
Well, thank you, Ranking Member Franks. I think we have a pretty impressive record of impact and success when you look at how we have tackled healthcare fraud since January 2009. One of the most important things that we did in May of last year at the direction of the President was to form something called the Healthcare Fraud Prevention and Enforcement Task Force, HEAT, which brings together the Department of Justice's resources with those of the Health and Human Services Department and Secretary Sebelius's resources in a coordinated way that is really unprecedented. It is sharing data, sharing information, sharing resources, and creating efficiencies which allow us to be much more effective in combating healthcare fraud. And there have been two things which have come out of that. One are the strike forces, which are being directed by the Criminal Division, which have had enormous success, and then the increase, as I talked about in my oral statement and is in the written testimony, the increase that we've seen in the recoveries, the civil recoveries of healthcare fraud. So I think that we are making the most of the resources that we have, and the President's budget reflects those additional resources that we think we need.
Well, Mr. West, this country has also been going through a subprime mortgage crisis that's had a great impact and great cost to investors and banks, and has forced many Americans, of course, to lose their homes. And certainly much of this crisis was brought about by poor underwriting standards and people borrowing more than they could afford. I think we all know that. But mortgage fraud has also played a significant role in the subprime mortgage crisis. And what is the Civil Division doing to go after these individuals or groups that have taken part in mortgage fraud schemes to help prevent mortgage fraud in the future?
Mortgage fraud is one of the most difficult challenges that the nation faces, as you correctly point out, and it is one of the highest priorities that we have in the Civil Division. The President last November created something called the Financial Fraud Enforcement Task Force, which brings together a wide array of federal agencies as well as state and local government law enforcement agencies which are focused on financial fraud. And one of the key components of that task force is the Mortgage Fraud Working Group, which I am a co-chair of. And just this past year, we began a series of listening tours, really, summits, mortgage fraud summits. The last one we held, in fact, was in Phoenix. And where we went were those areas where the data showed us that the mortgage fraud challenge was the most acute, and where we believed we could find some of the best practices where communities and law enforcement and industry were working together to try to tackle this problem. One of the things that came out of that was Operation Stolen Dreams, which was the massive mortgage fraud sweep that we just announced last week, where we have a record number of civil enforcement actions, over 190, a record number of recoveries, $147 million when it comes to mortgage fraud. And so we are actively engaged working with our state and local partners and the U.S. Attorney's offices around the country on this issue.
Well, thank you, Mr. West. I wish you the very best. And, Mr. Chairman, I'm going to go ahead and yield back at this point.
Thank you, Mr. Franks. I now yield to Mr. King of Iowa.
Thank you, Mr. Chairman. Mr. West, thanks for your testimony. First, I have a softball question for you to kind of break the ice here. And that would be the Office of Immigration Litigation. The acronym for that is what?
Oil.
Have you considered changing that particular thing?
Well, there's some things that are easy to do in government and some things that are not. I don't think changing the name of oil is one of those easy things.
Well, that's good. I'm glad you're comfortable with that, and I won't belabor that point, but it just caught my attention. And let me see. I'd like to start down here with the activity that you've had with regard to the impending litigation on the Health Care Act. And I would just pose this question to you. What if you prevail, and as I understand your argument, and rather than go into it very deeply, if you prevail, it'll be on your argument that the Commerce Clause grants constitutional authority for the federal government to pass legislation, which we know now as Obamacare. Would I be correct on that?
Well, if I could answer you this way, we certainly believe the law is constitutional. We believe that we will prevail in court. But I think it would be appropriate, given that it is pending litigation, that I allow our pleadings to speak for me on that point.
In other words, you'd rather not comment until it's litigated?
Well, certainly. In fact, we'll have the first opportunity. We have filed. I'm
helping you shape your argument, though, Mr. West.
We have filed certainly in Virginia and in other states, in Florida, where you can see the arguments as clearly laid out, sort of why we believe the Affordable Care Act is constitutional. But
my question to you then is, if the Commerce Clause is a component of that argument, and by your testimony it is, then what would be left of the Commerce Clause should you prevail on that point?
Well, again, I think I'm going to allow the litigation to speak for me. In fact, next week will be the first oral argument in this in one of the various cases in Virginia.
And then I would submit that if you prevail on the point that it's the Commerce Clause, then there would be nothing left of the Commerce Clause, in my judgment, because there always has been babies born within the states that don't have access or utilize any kind of health care that live and die. And so they would still be compelled to buy health insurance under this program, or under this legislation. So I was just going to take this argument for you to consider, because you have to be nimble when you face these people that are smart attorneys. And it's there. Somebody's already gone back to Wicker versus Filburn and said that even though he raised the wheat and ate his own wheat and didn't sell it to anybody, it affected the overall supply because he would have bought the wheat from somebody else. That's the Commerce Clause, right? Now I think it's a completely weak argument, and it's been weakened otherwise. But now Obamacare does this. If you look at Wicker versus Filburn, and it takes it to another level. It takes it to this level that says government either raises the wheat, or the health care in this case, or approves those who do, and approves the product, and requires everyone to buy wheat and eat wheat. That's your Commerce Clause argument. So I put that into the record so you're nimble enough to deal with that when the time comes, Mr. Weston. I'd really rather spend our time, though, talking about the Arizona immigration law. And I'm going to toss you out the judge post softball that surely you have prepared yourself to respond to when you're asked, have you read the bill?
Oh, yes, I have read the bill several times.
And as have I. And I appreciate that, because now we have a basis of understanding here. And the news reports have reported that you've issued a draft, that you have an internal document that would be a draft civil complaint in preparation to bring suit against Arizona on SB 1070. Is that correct?
Congressman, I'm not in a position to make any announcements today about that. We are working through various issues in connection with that issue. I do anticipate that the department will make some type of announcement fairly soon.
Okay, but Mr. West, I'm reading from a news report here. This is Fox News, June 18th. Obama administration planning to file suit against Arizona immigration law. I believe this article, and I don't have it highlighted here, but my memory says that your department has produced a draft civil complaint. Does that exist?
Well, I can't respond or to the news report that you. In fact, I don't think I've even read it. That you.
Can you respond to my question as to whether you or your department have produced a draft civil complaint?
Well, again, we are still working through various issues. I think it would be inappropriate for me to get into any type of internal deliberations that we have at the Department of Justice. I can say that this is an issue that...
It's pretty astonishing, actually, Mr. West, that not to be able to answer a question like that. It's not like this affects any pending litigation. Whatever you're doing internally, you're apparently advising people on how to act according to Arizona's immigration law. And if there's an internal document known as a draft civil complaint, I would think that you could tell us. It's been discussed as far up as the Secretary of State. And so I wouldn't think that there'd be an impediment to answering a direct question like that.
Well, again, I'm not in a position to make any announcements today about that, and I think it would be inappropriate for me to comment on internal deliberations.
Let me ask you then, since you've read the bill, and you're familiar with the preemption, do you read anything in the bill that would be preempted by existing federal statute?
Well, again, I think, at this point it would be premature for me to share my own thoughts on this. I think one of the important steps that we have taken is we have, in looking at all of the issues regarding this bill, this law, I have personally gone out to Arizona. I've wanted to get the input of the Attorney General out there, the Governor out there, because it's important, law enforcement officials, because it's important for us to take into consideration all of the varying views that folks have on this particular issue. We are still working through various issues, but I do anticipate that soon the department will make the.
Have you had any contact with the ACLU on this? Have you reviewed their lawsuit? Had any contact with them?
Again, we have reached out to law enforcement, to a number of different interested parties,
including the ACLU.
Quite frankly, I don't know.
Time is up.
Mr. Chairman, I just ask that the gentleman be allowed to answer the question as to whether he's had contact with the ACLU.
I don't know the answer to that question. I personally have not.
Thank you.
Thank you,
Mr. Chairman.
Recently, Mr. Lawrence Wilkerson, Chief of Staff to former Secretary of State Colin Powell, said that President Bush and others in the administration knowingly covered up the fact that hundreds of innocent men were sent to Guantanamo out of fear for their release, for the fear that their release could harm the push for war in Iraq and the broader war on terror, that they knew what they were doing and did it and knew it was illegal. Given the severity of those allegations by such a distinguished gentleman in that position, what does the Civil Division intend to do in following up on these allegations? Is there an investigation that you're going to pursue?
Well, Mr. Chairman, I wouldn't be able to comment on whether or not an investigation has been launched with regard to that. I think, I can certainly assure you that to the extent that there are any violations of law that fall within the jurisdiction of the Civil Division, to the extent that there is a Civil Division component that would be implicated, it would be the type of, and again, not speaking specifically about this case, but in any case, it would be the type of thing that would get some type of attention, but I can't confirm or deny any type of investigation.
What's the status of Yucca Mountain nuclear waste litigation?
Well, we are engaged in various lawsuits involving spent nuclear fuel with individuals, with companies from the nuclear industry. They are in various stages of litigation. Some, and I think beyond that, I probably couldn't comment specifically on where we are. But
how much money's been spent on attorneys on this case so far?
I don't know the answer to that question. Because
you have a ballpark figure?
You mean for both private and public attorneys? I don't know the answer to that question.
Ballpark figure?
I don't even have a ballpark figure. I think I would have to know a little bit more about the billing rates of the private attorneys involved in those cases.
How much discretion does the Justice Department exercise in determining which cases it's going to pursue? Has the Justice Department had any opportunities where they could decline? You can decline to defend an action, can you not? Or are you obligated to defend every action or represent?
Well, no, there is discretion. There is certainly prosecutorial discretion, and within the Civil Division, we exercise discretion on, whether or not we will intervene in a certain case or whether or not we will pursue a certain case. And so certainly there is an appropriate role for discretion to be exercised.
Have there been times when you can cite to me where you've exercised this discretion and worked out, resolved a case rather than take it to the Supreme Court because you thought that the facts were different than maybe the other administration had?
I probably would not be able to cite a specific case, not because there isn't one, but because I don't know if it would be appropriate to.
I don't see why it wouldn't be appropriate. If you settle the case, it's a case of the United States government, and part of transparency and openness is to disclose those things. There's no problem in disclosing that, Mr. West.
Well, certainly not disclosing settlements, you're right, and I'm happy to talk about settlements, but if the question is, are there cases where we looked at the facts in an investigation, made a determination that we would not either prosecute or would not go forward, and it did not result in a public settlement, then that would be inappropriate for me to comment on. But I'm happy to talk about, Mr. Chairman, if there are many settlements in which clearly we have decided to compromise those.
Can you give me a few examples of cases where you decided, because of policy differences between this and the previous president, that rather than continue litigation, you have engaged in negotiations and come to a settlement?
Well, because of policy, I'm sorry, I misunderstood your question. I think there are two very good examples. One is the Cobell litigation involving Native Americans. Another is the Pickford litigation involving African American farmers, which, by the way, we appreciate the Congress's movement on both of those cases, and we hope that the Senate will follow suit.
There was a problem, I guess we had with this. I don't know how much we got on the Pickford case, but there was more money that some wanted, and the issue was, did it need a pay-go? When the United States government settles a case, shouldn't the Secretary of Agriculture find a way to pay it? I mean, why should he be bound by pay-go when the United States Justice Department has settled the case? That's an obligation of the government at that point, right?
Well, Mr. Chairman, I think I would defer to the Secretary's response on that. Certainly, as you know, when the Civil Division evaluates a case, it's evaluating it from the standpoint of, is it money that ought to be expended out of the judgment fund? Is that an appropriate use of public money to compromise a case?
I've yielded. Like to go on, or we can.
Thank you, Mr. Chairman. I'll be really brief. The Civil Division has filed, Mr. West, motions to dismiss both lawsuits brought by states challenging the constitutionality of the recently passed health care law. And I'm just wondering if the Office of Legal Counsel has issued an opinion on the constitutionality of the health care law, and if so, can you provide the committee with a copy of that opinion?
I can certainly check and see. I am not, as I sit here, I'm not aware of that, but I can certainly check and get back to you.
I appreciate it. All right. For the record, Mr. Chairman, I hope we can make that an official request, at least on my part. In this Congress, Representative Nadler introduced H.R. 984, the State Secrets Protection Act. And, of course, I'm concerned, being on the Armed Services Committee and some other committees, that this could potentially be a threat to our national security. I think it potentially endangers it. But what is your department's position on H.R. 984? Are you concerned that the bill threatens U.S. national security in any way?
Well, I'm not aware that the department's taken a position on that bill. I can tell you that the department has instituted, the Attorney General has articulated a state secrets policy. It is a new policy that we follow before any assertion of that privilege is made, and the legal standard that we implement is to protect against the unauthorized disclosure of any information that might cause significant harm to the national security.
So then, if I'm understanding you right, you have a policy in place. Do you think you need additional congressional legislation to deal with that issue?
Well, again, I'm not aware of the department having taken a position on that case. But
What's your
certainly-
position?
Well, my position is I think we would be always welcome the opportunity to talk about these issues with Congress, and we would welcome the opportunity in this instance as well.
But I mean, you talk about any issue, wouldn't you? That doesn't mean you have a position on it.
That's true, and certainly I would not be the one to announce as a matter of first impression the position of the Department of Justice on this issue. But I can say that the Department's state secrets policy is one which reflects our concern that it be asserted only in those instances where it's absolutely necessary, that it be narrowly tailored, but that it be tailored to protect against any significant harm to the national security.
I think that's the best I'm going to get, but thank you. That's pretty good, actually. Thank you, Mr. Chairman. Thank you, sir.
Thank you.
Are in votes, Mr. King, if you'd like to ask a few questions, but go ahead.
Thank you, Mr. Chairman. Mr. West, I have drafted a letter that I sent to Attorney General Holder. It's dated May 28th, and it's only addressed to him, and it has to do with a request for a copy of the draft civil complaint that I referenced earlier in our discussion, which you have not acknowledged yet of his existence. And I would just ask you, should I have addressed that letter to you? Have you seen that letter?
I have not seen that letter, Congressman, but I'm happy if you'd like to send me a copy, or I can pick one up before I
Actually,
leave.
I could have my aide hand it to you right now.
That would
It's
be
very
fine.
short. And I would ask unanimous consent to introduce that letter into the record.
Without objection.
Thank you, Mr. Chairman.
Thank you.
And it's very brief, and I won't belabor this point. It simply asks for a copy of the draft civil complaint, and I understand that you won't be in a position to respond to that letter here, and I won't put you on that spot and ask you, Mr. West.
Appreciate it.
Thank you. And but I would like to explore this Arizona case just a little bit more. And also, I think I may have put some words in your mouth in the earlier exchange, and I'd like to have provide that opportunity for clarification, because I believe I said that you or your department had argued that the interstate commerce, the Commerce Clause, was a component. I have read that in the news, but I don't know that I've read a quote from the Justice Department on that point. So would you care to clarify as to whether that is on the record one of the arguments that would be made by the Justice Department?
Well, I can certainly say that in the briefs that we have filed, several of the cases that have been filed challenging the Affordable Care Act raise the Commerce Clause issue. They make Commerce Clause arguments, and we have responded in kind. So, we are responding to suits that have been filed, and our responses, motions to dismiss, respond to arguments based on the Commerce Clause that plaintiffs have raised.
Okay, fair enough. I just wanted to make sure that we had the record clear, and I didn't push you into something that wasn't your position or imply something. Because I recall the testimony of the Attorney General here some weeks ago before the committee, and I think most everybody in America saw some clips from that. And in that testimony that day, without putting words in the mouth of the Attorney General, I will submit that he conceded the point that he had been directed by the President, or the White House at least, to bring suit against Arizona's immigration law. And when questioned about where he might have concerns about Arizona's immigration law, SB 1070, question about what points in the Constitution might be unconstitutional, what federal statute might preempt Arizona's law, or what controlling case law might be the concern that would bring the Justice Department to bring suit against Arizona, the Attorney General wasn't able to answer any of those questions about the Constitution, federal preemption, or case law. Subsequent to that questioning, he acknowledged he hadn't read the bill, but he had been directed to bring suit against Arizona. And at the end of his response to my questions, he was allotted time to respond to my questions after the clock had run out, and he said that the office is not politicized. It's hard to accept that statement when there's a suit that's being brought by the Justice Department against a law that's been passed by a state that mirrors federal law. If federal law is constitutional and the legislation itself says that it will conform with Arizona and the U.S. Constitution. It's hard to accept the idea that the Justice Department is not politicized if a decision can be made in the White House, directed to the Attorney General, acted upon by the Justice Department, including your division within the Justice Department, and you're the first person that's come from the Justice Department that's actually read the bill. You recognize how hard it is for us here on this panel, representing the voice of the American people, to accept the argument that the office has not become politicized. What else could be the motive if the President has made this order, or the people that speak for him, and nobody's read the bill? What otherwise could be the motive, and how could the Justice Department act on anything other than the law itself and the equal justice under the law, the blindfolded Lady Justice that I mentioned in my opening remarks, Mr. West? Those trouble me, and I appreciate your response.
If I, just to clarify, the question that you'd like me to answer is, because I'm sorry, I just didn't quite.
How can we be asked to accept the statement of the Attorney General that the Justice Department is not politicized in the face of all of this evidence to the contrary, much of which I haven't stated today?
Well, I think really the only way that I can answer that is, and I appreciate the perspective that you have, is that the Attorney General really thinks of himself as a career Justice Department attorney. He grew up in the Department of Justice, started there as a line attorney, made his career there, and I know that he is committed in an unwavering way to a nonpartisan, non-politicized Department of Justice that acts to do what is in the best interest of the United States and the American people. You know, for me, I got my start as a Department of Justice attorney. I think of myself very much as a line lawyer. I was an AUSA for 5 years, and before that was a line attorney was an attorney in Maine Justice. And I think one of the things that the Attorney General has articulated well, and one of the things that I've always loved about the Department of Justice, is that it is one of the few places in this country where you can go and your overriding charge is to do not what's popular or partisan or political, but to do what is right. And I appreciate that there may be differences of opinion on whether or not one is doing what one is doing, you know, in alliance with any particular view of the world. But I guess the only way I can answer that question is to say that I appreciate the perspective with regard to this particular law, this particular litigation. We have endeavored to get the input of the Attorney General of the state of Arizona, the Governor of the state of Arizona. It is something that we take very seriously, and we continue to work through various issues.
Mr. West, I appreciate the manner with which you've conducted yourself here at this hearing today, and also the difficult position that you might find yourself in today. So thank you very much for your testimony. I yield back the balance of my time.
Thank you, Congressman.
Thank you. I'd like to thank the witness for his testimony today. Without objections, members have 5 legislative days. There's been additional written questions which are forwarded to the witness and asked him to answer as promptly as he can to be made part of the record. Without objection, the record will remain open for 5 legislative days for the submission of any other material. Thank you, Mr. West. The hearing is adjourned.
Thank you.
Hey, Wendell.